Were you surprised by it or no?
Andrew, I'm not surprised. Then each of the judges in Florida and New York, they got it right. Under the rules of criminal procedure, and we're talking about Rule 6, grand jury transcripts are secret. They're sealed. They're not to be unsealed just because there's a lot of public interest in the case. There's very few legal reasons why they can be unsealed. And even the judge said it in this case. Really unsealing the transcripts in the most recent case really wouldn't add a whole lot. It's just a fraction of the evidence in this case. It's mostly law enforcement witnesses. So, for folks that don't know, grand juries really serve two functions. One is to investigate, and an investigative grand jury may have subpoena documents that would be in DOJ files already, and they hear testimony. Oftentimes, because the rules of evidence don't apply, if you're a prosecutor, you don't necessarily put victims before the grand jury. You have your law enforcement witnesses summarize some of that testimony. That protects the witness and doesn't create impeachment evidence that could potentially be used against them at trial. So, when you have these summary witnesses before the grand jury, they're not necessarily going to add a lot. For people that want the Epstein files, it's really those FBI memoranda, those 302s, those 402s. That's in Pam Bondi and Cash Patel's possession. They could release all that. So what they're talking about is a small fraction. There's no legal basis to unseal it. And it probably wouldn't add a whole lot to what we already know and wasn't made public in both the civil and criminal cases.
Yeah, Nima, just lastly, part of the judge's reasoning in this, he said a significant and compelling reason to reject the government's request was that the information contained in the very transcripts, quote, pales in comparison to the Epstein investigative information and materials in the hands of the DOJ.